I want to bring in CNN legal analyst Norm Eisen, who is the White House ethics czar under President Barack Obama. Also, Seth Berenzweig, a trial and compliance attorney as well. Gentlemen, so glad to have both of you here. Before we get to what's happening in Mar-a-Lago, the fact that you have the feds not giving over information to Alvin Bragg's team, and now he has to be the one in court saying, actually, Your Honor, I might need a little bit of a delay, that's not where he wants to be.
It's not, and it's unconscionable. Alvin Bragg asked for these materials. It was over a year ago. To hold them back and to wait for a subpoena from Donald Trump and then dump. So far, we had an initial dump of 70,000. Then in the past week, another 30,000 plus with more coming. I really fault the federal prosecutors here. The Southern District of New York has some of the best federal prosecutors in the country, but they're known for hubris, for arrogance, and that's what we see here. Alvin Bragg and the administration of justice and Judge Marchand and all of us are the victims of that.
Well, we will see what this judge ultimately decides. Of course, the fact that two parties are willing to have a delay, and of course, Trump's team wants the delay. Now that Alvin Bragg's team is saying, I guess up to 30 days, it's going to get pushed back, undoubtedly. Seth, let me turn to Mar-a-Lago, though, because Trump, speaking of delays, how about the other D word, dismissal? He is trying to dismiss the case against him in Mar-a-Lago, and he went to Judge Eileen Cannon today. And the first argument he made is that the Espionage Act is unconstitutionally vague, and therefore he can't be prosecuted under it at all. She was skeptical of that and instead said, this ought to be maybe a jury instruction or a way to clarify it. Why do you think she was so skeptical?
Well, I think she wanted to punt on the issue. There are a total of 9 motions to dismiss, and you have to credit Team Trump. They're quite good at filing motions, and while they lose on the substance, they win on the process because they're running the clock, and they've done it in a very effective way. What happened today was that the judge said that she was very skeptical and was likely going to dismiss the argument with regard to unconstitutional vagueness on the statute, and also that somehow President Trump, then President Trump, and then former President Trump had the right to be able to retain these records under the Presidential Records Act. None of those arguments are strong. And what's frustrating about this case is that it's supposed to be one of the simplest cases. This is not a complex case. This is not one of those cases that really is going to take a long time to put on. But the fact that there and yet delay. So, you know, it's really kind of a microcosm of what's happening in the Supreme Court right down the street from us here, where the Supreme Court is holding back Judge Chutkan. And I know we're not getting into any depth on that tonight, but you have to hand it to Team Trump. When it comes to filing and delays, he really has the all-star team.
I mean, you're a defense attorney, so the idea of making a prosecution team prove their case, part of that is the motion practice. Part of that is making sure every I is dotted and T is crossed. And if there's even like a faint ink blot, that's it. But in this case, he's talking about not only the Espionage Act, but he's trying to draw comparisons to himself and Biden and saying, wait, hold on a second. Biden had notebooks. You talked about with her special counsel hearing this week. I had notebooks. Same thing. She was not buying it, though.
No. Even Judge Cannon, who has been so partial to Donald Trump that she's been reversed twice by the extremely conservative 11th Circuit, even Judge Cannon gave Trump's lawyers a hard time today. There's no comparison between what Biden did with following along. It was wrong what Biden did. He should not have kept those classified documents. But there's a long pattern of presidents hanging on to documents. He cooperated with Donald Trump. You have a vast number of documents and a refusal to cooperate, alleged obstruction. Then he has this insane Presidential Records Act argument. It was one of my jobs when I was ethics czar to make sure we all complied with those rules. He's saying that official secrets about military preparedness and nuclear weapons, that those somehow can become personal. That's like saying it's the opposite of personal. That's not what the law means at all.
And by the way,
she pressed on that, and she threw out his vagueness argument.
By the way, there was that moment. Do we have the sound of him talking about from Bedminster, I believe it was, saying that in fact he was aware that. Well, let's just play it. Let's play it.
I was just saying, because we were talking about it, and he said he wanted to attack Iran and what. These are the papers. This was done by the military, given to me. I think we can probably, right?
I don't know, we'll have to see. Yeah, we'll have to try to
Declassify
figure out
it.
yeah.
See, as president, I could have declassified
Yeah.
it. Now I can't, but this is
Yeah,
classified.
now we have a problem.
Isn't that interesting?
As president, I could have declassified it. Now I can't, and it's still a secret. Sounds like notice in terms of your notion of this being pretty clear cut.
Yeah, exactly. And one of the elements that Judge Cannon said today is that with respect to the vagueness issue, and some of that went to the word of intent, she said, well, we can raise this on jury instructions during the trial. So she kind of punted. But the thing that's interesting is that when you go through jury instructions, those have to be based upon and foot to the evidence. So where is the defense going to be able to point to evidence with regard to intent that reflects favorably on Mr. Trump? Now, in fairness to him, we don't know exactly how the trial is going to unfurl, so we'll see. But when you look at evidence like that and the jury gets an instruction on intent, I think that's one of the reasons why I think this is one of the most compact cases, which is one of the reasons why it's so surprising that it's taking so long. I think it will get tried before the election, as will the case in New York, but this is just dragging on. It's like watching paint dry. These things really ultimately have to get up on the docket.
As my son, I told him, watch pot never boil, so we proceed to boil water and time it. But tell me, do you think that's true? It's going to go before the election?
I do think that there is room for two cases to take place before the election. And you have the Bragg case. It may be slowed down by this document dump, but probably not for very long. And then that case will finish. That it will take, let's say, 2 months. That case will finish. And then you have the summer and the fall with three contenders, like three racehorses. Will it be the Mar-a-Lago documents case? Will it be the Jack Smith federal election interference case? Or will it be Fani Willis's Georgia case? Of course, tomorrow we'll decide if she's disqualified. That case comes off the board, and it's either Mar-a-Lago. It's the two Jack Smith cases.
My money's on Judge Chutkan. I think that even though the Supreme Court's hearing this presidential immunity case in the last possible moment, in the last week of hearings, she's going to be ready to go. And I believe that this is going to be a trial that will happen after New York. And she's definitely focusing. Her approach is fundamentally different than that of Judge Cannon.
All right, well, we got three racehorses. Get your mint juleps ready. Norm, Seth, that was a Kentucky Derby reference. Are you guys kidding me right now? Okay, I'm funny. Anyway, we're moving right on. Thank you so much, Norm and Seth.